Hello, everyone. I hope you're keeping safe. Welcome to today's session where we shall be discussing the management of intellectual property. We really appreciate you joining us today, and we hope that you're going to learn as much as possible. My name is Grace Nzula. I am a trainer and HR consultant with Atara Solutions, a training and HR consulting firm, and a manager at Panesa's Training Institute, a carpentry school. Get It Right with Atara Solutions to do with entrepreneurship and employment. We are in partnership with the Lego Academy, a software development and capacity building academy, and IT Support Services, a brand management and communications company. This is our 7th webinar. The first one, we looked at the legal requirements of starting a business. We also looked at brand management and communication. The second one was to start. The third time, we had Mr. Panessa, who shared with us his journey in running a business for over 40 years. The fourth one, we had Mr. Karundu, who defined for us the needs of our customers through bookkeeping and what the taxman wants. Last week, we hosted Mr. Joram Winamo, who took us through business strategies. Visualize it, win it. If you missed any of our webinars, please visit Atara Solutions YouTube channel, and while at it, kindly subscribe. Next week, we shall be discussing what employers want with their people. Let me share some facts and points to note. Did you know that 22% of businesses fail in the first year, 30% in the second year, 50% in the fifth year, and 70% in the 10th year? This is the narrative Get It Right with Atara Solutions is trying to change. I am so pleased and honored to introduce to you our speakers of the day. They are both partners at Mutune Kenywa Advocates, and they are both experts in intellectual property. Nyawira is a partner in the firm with over 11 years post-bar experience in legal practice. She specializes in, obviously, intellectual property, telecommunication, corporate and commercial law. Faith has also over 10 years experience in the practice of law, who specializes in intellectual property and ICT law. We invite you, our audience, to ask as much as possible. So Faith, intellectual property, take us through.
Thank you, Nzula, for that wonderful introduction. I have nothing more to add on that introduction. It was a very good introduction. Thank you very much to the viewers for joining us today. The topic of the day is intellectual property basics. And the reason why we chose to do the basics is because we understand that intellectual property as a topic has not been covered in this platform before. So we thought before we get into the issues of management, we want to cover the basics of IP. So as we go through this session, we want to cover an introduction to IP, help you to understand the different categories of IP, help you to understand how to protect IP, and also how to enforce your intellectual property rights. So the subject of IP generally is a very wide subject. So we'll try to cover what we think is important to you, the viewers, who I understand also a majority of you are people who are in business. And we hope that at the end of the day, it shall be beneficial to you and to your business. So getting onto the subject, we want to start with understanding what intellectual property is. Intellectual property is basically creations of the mind. They can be done by an individual, corporations, or other entities that we claim them. When you think of intellectual property, think of books, think of movies, think of drawings, think of works of art, photographs, broadcasts, think of slogans, names and logos and taglines. Think of any specialized packaging for any unique shape or color or design that you may have with your business. If you are in business and you have a website, think of that too. Think of computer software and hardware, beauty and cosmetic products, services, plant varieties, customer lists for your businesses, instructional manuals, catalogs and content for your website. all that is intellectual property. So when you're going through business, you will realize that you will interact with any one of these aspects of intellectual property. Now, what I have introduced to you is the forms of intellectual property. So what are intellectual property rights? Intellectual property rights basically are the legal rights that you are given to a creator to protect his invention for a certain period of time. It has two characteristics. It is limited to a certain period of time, and it enables the creator to gain economically from his creation. So what are the types of intellectual property? I'll just mention them by name because my colleague will tackle like these types of intellectual property in depth. They are patents, trademarks, copyrights, industrial designs, utility models, trade secrets, and confidential information. So what are the benefits of protection of intellectual property? When you protect your intellectual property, you have exclusive rights over your creation and invention. What does that mean? It means that you get to determine how your intellectual property is used by third parties. A third party cannot use your intellectual property without your permission. It also means that you get to earn money from your IP. That is through reproduction, through sales, through licensing, through franchising, and any other type of model that you may think of where you can actually earn money through your IP. It means that you are differentiating your product from other products in the market. You do not want other people who are in the market to have a product that looks like similar to yours. That will mean that you will get a brand dilution. But if you want to differentiate your products, your services, you want to secure your IP. It will enhance your worth, the worth of your business in the eyes of investors. Investors will ordinarily not touch your business until you have protected your IP. They need to be sure that when they put the money in your business, that business is going to will grow and will be sustained. And that cannot happen if your IP is not protected. It will raise the value of a business in the event of a sale or a merger. What happens during a sale or a merger is that there is audit of your business and there is valuation of your business. Now, IP is an asset. So during valuation, if your IP is properly protected and properly utilized and commercialized, it raises the value of your business during the sale or the merger. It enables an individual or a business to gain access to funding using IP asset as a collateral. When your IP is properly protected, and when your IP has been registered with the proper registration, through the proper registration mechanism, you can use that registration and what you have done, the steps you've taken as commercialization, to secure funding from a financial institution, to secure funding from any other investor. It gives you, it establishes a proper record of ownership, so there is no doubt who owns that IP if it has been protected. And then it strengthens a copyright owner's position in a copyright infringement case. Actually, with the strengthening your protection, it actually applies across all of them, such that when you have registered your IP and somebody is claiming that you have infringed their IP, or you yourself want to enforce your IP and you have registered it, it becomes very easy for the court to determine who the owner of the IP is, and therefore you're likely to just win that matter. So I think I will stop there because the next topic I'm supposed to cover will be after my colleague introduces the type of IP.
Good evening. Thank you very much, Faith, for that background that you have given us. I will take us through the different categories of IP in a generalized manner so that we can have a better understanding of what the different IP categories are about. We will begin with patents. The patents are enforceable exclusive rights granted by the government in return for disclosure of an invention to the inventor. What this pretty much means is that once you have an invention and you would wish for that invention to be registered or to be protected, then that is what we call a patent. So we can look at what is this that can be patented. It can be a device, it can be a substance, it can be a method, or it can be a process. For the patent to actually be eligible, it would need to be novel. That means it needs to be new. It needs to be something that is not already there, especially in that particular jurisdiction where you want to protect the patent. And it needs to have an inventive or a non-obvious step. That means that in the process of this, in the invention that you have, it needs to have an aspect of it that is not obvious, that is not something that can be found in another invention that has been registered before, or that has been known to exist before. And then the third aspect for it to be eligible for registration is that the invention must be industrially applicable. That pretty much means it needs to be useful in the industry within which you want to protect that invention. The features of patents generally are that it is territorial. That pretty much means that you would need to, once you register a patent in a particular say country or a particular jurisdiction, it means that that patent has only been protected in that particular area. It doesn't mean that you have, that patent will be, say, it will be applicable to another country or another jurisdiction. It will only be applicable to that particular jurisdiction in which you have registered it. It is also not automatic. That pretty much means that you will have to register it. It doesn't accrue automatically after you have the invention. You would have to take steps to protect it. The process generally of patent registration is that you need to file the patent. The patent is actually, filing the patent involves filing the patent document. The patent document is what will actually contain the details and the specifics of what it is that you intend to, protect, the invention that you intend to protect. It's a very detailed document that has both the technical aspect of it, depending on which fields the patent aims to cover, and it will also have the substantive, I mean the legal aspect of it, which means now that you have to protect the rights that accrues as a result of that invention being registered. After you file the patent, a search will be conducted, and also a substantive examination. These ones will be done by the relevant institution, which in our case is KIPI. They're the ones who will do for you the search. This just pretty much will tell you if there is somebody else who already has registered a similar invention. Substantive examination will now go into the details of the invention to find out that you have actually complied with what is supposed to be complied with, where concerns that invention. There's a set guideline that KIPI normally has, which they have to make sure that your patent document complies with it. Once they realize that once it is established that you have complied, then it will be published. The application will be published. This will give an opportunity to anybody out there who may have an objection to the patent being registered to have the opportunity to actually voice their or register their objections to that patent being registered. In the event that that process passes and there is no one in the public who is objected to the registration, the patent will be granted, it will be registered, and then now the patent in itself will be published in the KIPI journal. The period of protection where patents are concerned is normally 20 years after, but for each year of the 20-year period, you would have to renew, you would have to actually renew every year. The renewal is every year, subject to which if you don't renew every year, then the rights will lapse. So you have to renew every year for that period of 20 years. But after 20 years period has lapsed, then the patent just remains in the public domain. It cannot no longer be protected under intellectual property. So the period of registration pretty much covers how long it takes to register a patent in Kenya. So it will take anything from a minimum of 1.5 years to 3 years. It's actually quite a lengthy process, which will take about 1.5 to 3 years. So that is for the national registration. You can, however, protect your patent in more than one country, meaning that you can protect the patent in more than, beyond Kenya. And to be able to do this, you can take advantage of a RIPO. A RIPO is a registration whereby you are able to protect the patent in 16 different African countries, or you can also do it through the PCT, which covers 141 countries. The period within which to protect your patent in this in the regional and international registration is between 20 to 30 months. So we will next move to copyright. So copyright describes rights that creators have over their literary, music, and artistic works, audiovisual works, recordings, and broadcasts. This is really the scope of copyright. It's quite a wide scope. It's really covers what now we call creatives. So what is copyrightable? There's a range of things that are copyrightable. I've just given a few examples, which includes books, music, paintings, sculptures, films, computer programs, databases, advertisements, maps, drawings. That is generally the scope of what is copyrightable. And the features of a copyright is that it actually accrues automatically. Looking like for patents, you'd have to actually register the patent for it to be registrable. I mean, for it to be protected. But for copyrights, it is actually accrues automatically the moment that an author has created copyright. But for this to be so, it means that that work is original, meaning that the author has used his own skill, labor, and judgment to come up with the copyright. And at the same time, there's a fixation of the work in a tangible medium of expression. This is, for instance, where concerns say, for example, a comedian, for you to copyright, even if you have not actually registered for the copyright with the relevant body, which is Kekobo in our case, it would have to actually have been reduced to something that is tangible. For instance, a comedian would have had to record either in video form or in audio form for him to actually own, to say that now that is his copyright. So there's an advantage to registering the copyright itself, because now that becomes, it's an easier way to demonstrate ownership in case of a dispute or in case somebody is infringing on your right. And to be able to do this, there's a process, and it's usually undertaken in Kekobo. It involves the search, the filing of an application, The search is just to tell you whether or not it's copyrightable, whether somebody else has previously copyrighted similar work. When that passes, then you can just file the application and a certificate is issued. It is pretty much, it's a simple process. It doesn't take too long. It takes between 5 to 7 working days to be done. And with copyright, the advantage is that there's the Berne Convention, which pretty much means the moment you have registered it in Kenya, it automatically becomes registered in 178 of the 195 countries that we have. So you don't need to take any further steps to enjoy registration in other countries, because it covers at least 178 of the 195 countries. The moment you actually just register it in your country. So the period of protection varies depending on the type of work for which you are registering. If it is literal, musical, dramatic, or artistic work, it's going to be 15 years after the end of the year in which the author dies. So it's going to be protected for that period of time. For audiovisual works, it's going to be 15 years from the end of the year in which the work was either first made available to the public or first published. Whichever date is now the latest. For sound recordings, it will again be 15 years after the end of the year in which the recording was made. For broadcasts, it's 15 years after the end of the year in which the broadcast took place. Joint authorship, that means that there are two authors who have originated that particular copyright. So it will actually subsist for, it's going to actually subsist until to the death of the author shall be taken to refer to the author who dies last. Of the two who have been registered as owners, it will be 50 years from the death of the last of the two joint owners who passed on. And then anonymous or pseudonymous, literally music, dramatic, or artistic work, it will subsist for 50 years from the end of the year in which it was published. That is all on copyrights. So the next category we will tackle is trade secrets. So for the trade secrets, it's really confidential information that is of commercial value to a business. That kind of information that gives you a competitive edge over the other competitors of business. And we don't have currently in Kenya a law that safeguards trade secrets per se, but we do have other laws that can speak to the protection of trade secrets. That is what we use to guide where concerns trade secrets protection. And this is the Constitution of Kenya, which safeguards the right to privacy. And then the same Constitution also allows for international instruments, for example, the TRIPS, and the TRIPS is quite, the TRIPS agreement to which Kenya is a signatory, which allows, which then means that you are able to protect your trade secrets in accordance with the agreement, which is espoused in the TRIPS. And then there is Contracts in Restraint of Trade Act, which allows employers pretty much to restrict any of its employees from engaging for work in a similar nature. That, in essence, in other words, is what we otherwise call non-solicitation. It is also what we call non-compete. So then that means that when you're having employment contracts you can be able to put in non-compete clauses and non-solicitation clauses, which pretty much means that you can now safeguard whatever secrets, because you have stopped this person from actually engaging in another business of similar nature, which would mean, in other words, that they are, that they may take advantage of whatever trade secrets they learned when they were working with you. And then there's the law of contract, which grants parties autonomy to draw up contracts to protect their trade secrets. There's also common law, which is pretty much what guides the courts in Kenya when they are defining, when they want to decide whether in that case it has been demonstrated that indeed it was a trade secret that has been, it is indeed a trade secret that has been infringed by someone else, and it is called the reasonable measures criteria. That means that you need to demonstrate that you did take certain steps to protect your trade secret. We look at that a bit more later when we are talking about how to protect trade secrets. So generally, the information that can be protected under the trade secrets in Kenya is information that is of secretive nature and is not readily available in public domain, information that possesses commercial value, and any information where continuous and reasonable steps have been taken to keep the information secret. So then we go to how do you then protect trade secrets, because it is not, unlike the other ones that we have seen so far, trade secret is not really one, where you can actually register a trade secret. So pretty much how you go about protecting trade secrets is, for instance, by development of intellectual property policies within your business. This means that now you will be safeguarding whatever information that any employee that you have comes across as a result of interacting with the business. Another way of doing it is ensuring that when you're dealing with employees, when you're hiring employees, that you include the non-solicitation and non-compete clauses that we are talking about, and confidentiality clauses that we were talking about previously. And then also for suppliers, because say you're in the cosmetic field, and there is certain things that you do and there's certain processes that you undertake. And then you have this supplier that you have to tell, okay, this is how I mix my things, so mix it for me like this, and ship it to Kenya, for instance. So in that case, you can ensure that the agreement you have with the supplier is such that they are not at liberty to actually expose or talk about your whatever trade secrets you have or whatever formulas you have, so that is safeguarded. And then there's also investors. When you're, more often than not, we have instances where we want to onboard new investors in businesses. So you may meet one investor and then you want to give them, for example, you want to tell them about the business, which will probably include a trade secret. So how to safeguard that is that you have to have non-disclosure agreements or confidentiality agreements, whereby you state categorically that that person is not, whether or not they are onboarded into the business after the pitch, that they cannot share the information that has been shared as a result of you pitching the business or you trying to make the business known to them. Another way of protecting trade secrets is by restricting the information. You can have different levels of employees who know certain different things about the business. Not everybody has to know everything that you're doing. Depending on what they're bringing, whatever it is that they're bringing, then, or whatever duties they have, then you can restrict the information that you give or that you share about your business. So that will also protect your trade secret. So from trade secrets, we will now move on to trademarks as another form of, another category of intellectual property. So pretty much, a trademark is a distinctive word, phrase, symbol, or design, or a combination which identifies a product or a service. So we have very many different types. We have a couple of different types of trademarks, which it now depends on the kind of business that you engaged in. So for instance, we'll look at a few of them, and one of them is trademark for goods. That is as self-explanatory as it is. That pretty much means that you're selling goods, and so then you have protected the goods that you are trading in, as relates to now that particular good that you're selling. An example is the Coca-Cola trademark, which we all know. You could also have a service mark. That pretty much means that your business actually involves provision of services. An example is Uber. Then you can have collective trademarks. A collective trademarks is pretty much capable of distinguishing in the course of trade the services of particular class of persons who are associated in terms of the goods or services that they are providing. So for example, one would be like a matatu sacco, for instance. So they can decide that for this whole, as long as you belong in that matatu sacco, this is the trademark that we will use to associate ourselves to the business that we are performing. And then we have certification trademarks. Certification trademarks help to identify goods or services which meet a defined standard. For instance, we have Woolmark. Woolmark pretty much, if you buy a Woolmark, you just know that it assures you that you have actually bought a good or you've bought a product that is over 100%, has 100% wool. So that is pretty much a certification trademark. Defensive registration, this refers to instances where there's normally this classification of goods and services from the NIS agreement, which pretty much, depending on either the goods or the services that you are protecting, you can register the trademark under those particular classes. So defensive registration is where, for instance, you're actually in the business of making detergents, say, for instance, but the name that you have been using the registration that you have, the trademark that you have been using for a very long period of time has become so synonymous with you, such that if somebody else was to come and register, a similar trademark, they would be confused to have been people who have the same. It's like you're providing the same service. For example, somebody else, maybe you particularly registered it under detergents. Then somebody else who's providing a service comes in and uses the same trademark and goes in, because it's actually allowed for as long as you've not registered a trademark under a particular class, then the KIPI can allow anybody else to come and register it under a different class, the same name but under a different class. So you do a defensive registration, meaning that you want to stop anybody else who would come, who maybe has similar services or similar goods, so that someone cannot confuse the association between you and the other person. So that is what is called a defensive registration. A series of marks. A series of marks is where a person claims to be a proprietor of several trademarks to be used in respect of the same goods and services, which, resembling each other in material particulars, differ in regards to statements of the goods or services. Meaning that they are similar, but they differ in one way or the other, not distinctively, but in one way or the other, maybe in price, in quality, in color, in one of the aspects. An example is like Omo. Omo started from Omo, then there's Omo with Powerform, Omo with, so they kept having, so it's really the same product, but it differs not distinctively, but perhaps in quality, because they kept improving the ability of the detergent to actually clean the clothes, to clean your clothes. So that is what is referred to as a series of marks. So the features generally for trademarks is that it is territorial. Again, it means that once you register it in a country, it only enjoys, you can only enforce it in that one country. It doesn't cut across like we saw in copyright. that once you register in your country, as long as it is a member of the Berne Convention, that it automatically applies to all the other 175 countries. In this case for trademarks, you would intentionally have to have registered it in different in the different countries or under the different international or regional registrations to be able to enjoy the trademark in any other country other than the national country. Again, it is not automatic, meaning you'd have to register it in order to enjoy it. However, I need to mention there that there are those trademarks, or so to speak, we call them normally what anyone else would call is a brand. So there's these brands that have been around for quite a while, such that they've become so synonymous with a particular person who provides that particular service, such that even if you went to register it, you would not be allowed to register it because it is already established that this person is the one that uses this, has already established use of that trademark over a long period of time. Yeah, so that counts for trademarks as well. So the process of registration for trademarks is there's a preliminary search that tells you whether the trademark is available or that there is somebody else who has registered something of similar nature, so you're not able to register the trademark. The step is not mandatory, but it is advisable so that you don't invest in or take time to proceed with the other steps of registration, while in fact all the time the search would have just told you that there is somebody else who already has a certain, a similar mark. So the next step after the search, if the search checks out, then you can now submit the application. Then the KIPI will take it through a substantive examination. Once they are satisfied, they will publish it. Publishing it is really through the journal, the KIPI journal. They have a journal that comes out once every month, and that is where now you're able to, if there's anyone who has any objection about the registration, that is the point at which somebody would raise their objection about it. And if there's no objection, then the registration will be done and the certificate will be issued to you. So for trademarks, it is renewable every 10 years. So every 10 years, you can renew the trademark. The moment you don't renew the trademark, then the rights are distinguished. You cannot continue to enjoy the rights accrued. So in terms of period of registration, national registration, that is with KIPI, takes 6 to 8 months. That means that you are the jurisdiction that you're covered under is Kenya. And then the other, you could also do multiple registration. You could also choose to do multiple registration, of course, depending on your nature of business and where you want to conduct the business, which countries you feel that will have commercial value for you to invest in. And yeah, so pretty much it could be under a RIPO, it could be under the Madrid Protocol, and depending also on the nature of the trademark, you could also utilize the what is provided for under the Nairobi Treaty on Olympic Symbols. So on the categories that is all that we had. We go back to Faith to talk to us about enforcement of the trademark, of the intellectual property categories, how you can enforce your intellectual property.
I don't know whether we can bring back the presentation so I'm able to see it.
We have quite a number of questions as we wait for Eric to put up the presentation.
Okay. So
Nyawira, there's so many questions to you.
Okay.
Do we take the questions first or we finish with the enforcement?
No, we were waiting for Eric to finish.
Okay. So when it comes to IP protection, there are various things that you can do. So you can look at internal things that you can do as a company and also external measures that you can take. So for example, the first thing that you want to do is to do an IP diagnosis. Identify what your IP asset is. The thing about IP is IP should be looked at as a business asset. And in some cases, you will find that even the IP asset itself is actually more valuable than any other business asset that you have. So if, in fact, when you are able to identify your IP asset and do an audit and valuation, there is a lot that comes out of that process. So you're able to know what material do I have, what creations do I have, what inventions do I have that constitute intellectual property. And also, when you are able to identify, you are able to ensure that your employees also know that this is intellectual property, and so they know how to deal with it. Sometimes people may think that IP protection is very expensive, but sometimes protection of the IP can be the difference between whether your company grows in the next 2 years, 3 years, or whether you shut down your company because of so much infringement of your work and you're not able to defend it because you never protected it. So an audit would reveal all these things. And once you're able to do the audit, you also do the valuation. So you know the value of your IP. It is also important to keep very clear and good documents concerning your IP asset. So always have clear documentation of what you consider as your IP asset. And also, as Ms. Nyawira has pointed out, you need to do a search. In fact, you may want to do, before you even register a search, it is imperative really that, an IP, sorry, it is imperative really that you do a search. Because if you don't do a search before you invest in brand protection, you might spend a lot of money investing a lot of money in brand protection only to discover later that you're infringing on somebody else's intellectual property. And so you have to redo that process again. So you want to do a search even before you start putting so much money in IP, in your branding. With IP protection, you need to consult a professional. This is very important. See, what we're giving you here today is very general information, but IP protection will differ on a case-to-case basis. So it's really important that you get to sit down with a professional who will be able to assess all these first things that we've talked about earlier and guide you on the right way to deal with your intellectual property. You also need to register your intellectual property where it's registrable. For example, with the trademarks, patents, and utility models. IP applies differently in different countries. So you'll find, for example, that some countries, so long as you've used a trademark, you already acquire rights, even though you are not the first one to register it. But under the Kenyan law, the rule is that you must register it first. So first registration is really emphasized a lot in this country. You also need to consider, where do you want to register do you want to expand your business? Which countries do you want to register your IP? If it's a trademark, where do you want to expand your business to? What is the law relating to IP or trademarks in that law? And what can you do at this moment before you launch your product? What can you do to ensure that your IP is protected, so that now you don't come up with a product, you launch it here successfully, but when you try to register it elsewhere, after 1 year or 2 years, you find that somebody else has already run with it because you were too late. Ms. Nyawira has also talked about employees and third-party agreements and IP clauses, and they also come very much in handy also when you're dealing with other business partners and third parties. For example, you might find that you are the producer of you want to produce a certain good, but what you have the capacity for is maybe you have created drawings for that particular product, but you don't have the capacity to manufacture what you have drawn. So you're going to engage a manufacturer who is going to manufacture this particular product for you. What kind of an agreement are you entering into with this manufacturer? And are there IP clauses in this particular agreement that you're entering into? Because if you don't safeguard your IP, even when dealing with third-party partners, you may find yourself in a lot of trouble with infringement. You also want to do capacity building for your staff and for the top management. Everybody who you're working with in your organization needs to know about intellectual property. They need to know. Sometimes you will find that a lot of IP, let's say infringement, basically occurs within an organization because employees truly do not know that this is an IP asset that needs to be protected. And also, you need to embed protection of IP in your policies and procedures. All the time, your employees need to know that this is an IP asset. Sometimes they talk about it and they expose your secrets. They expose your customers list. They expose your formulas without knowing that this is actually protectable under the IP. You also want to limit access controls. You want to put a limitation on who gets to access certain aspects of your IP. That ordinarily happens a lot, even when it comes to trade secrets. For example, what I know is like, if you look at the case of Coca-Cola formula, that is protected under trade secret. So you will find that some organizations who are protecting their products under trade secret, what they do is that for example, if this particular product has 10 processes, you will find that employees have been banded into different categories. So some employees will know 1 or 2 processes, but they will not know the rest. Others will know the 3rd and 4th process, but they will not know the first one. Others will know the last processes. So that is how they've been able to protect this formula of theirs for so many years, because they are limiting the access to that particular IP. With IP enforcement, we want to first get into IP monitoring. IP monitoring is something that you can do yourself. In this information age, you can go into the internet and see whether there is somebody who has a trademark that is similar to yours, somebody who's and then also selling similar goods to yours. Sometimes, you know, if you're stocking goods in the supermarket, you can have, you know, guys walk around, see what is stocked next to your spaghetti. You have a spaghetti that is called Santa Maria, and then the next one there is Santa Lucia. And they have the same, you know, packaging, the same everything else. You know, you're able to identify because they are stocked together within in the supermarket. So you'll be able to monitor yourself. There are people who also engage companies that do IP monitoring. Well, that is not so developed here, but it can still be adopted because a lot of also intellectual property is stolen through the internet, more or less. Some people have also sort of like, they claim that they have come up with artificial intelligence that can be able to actually monitor your IP. I'm not so sure about it, but it is still in development stages. So in the next 1 year or 2 years, you'll be able to actually monitor your IP using AI. I think it's already being done with in other countries. Also, when you fall into a dispute with somebody who has infringed your IP, what do? There are several ways of dealing with this issue. You can pursue civil remedies, or you can do alternative dispute resolution, which now means that you're doing out-of-court negotiations and settlement of that particular issues. That will touch issues of arbitration. It will touch on issues of mediation. You know, it will touch issues of negotiation. So you will find like there are cases that somebody has infringed on your IP, but they did not know that they're infringing. So if you send them say a cease and desist letter, immediately you find that they are cooperative and they will cease infringing on your IP immediately. So you don't really need to escalate that matter into, you know, a court issue all the time. Sometimes, for example, if somebody has gone to the internet and taken your material and used that material on their internet, you can issue the internet service provider with a takedown notice, and the ISP will be able to take down that material that is infringing on your intellectual property. Other times, you know, when you're pursuing issues of ADR, you might find that when you're in the process of ADR, you can come up with the mechanisms that can help you deal with the infringement without necessarily stopping the person who is infringing on you. For example, if it's a trademark and you know you've invested so much in your brand, and somebody is now coming in and selling similar goods or services and using your brand, you can consider, you know, granting them a franchise and they pay you. So instead of now, you know, telling them stop, yet, you know, it is popularizing your product, you can actually enter into a license agreement. So there are all those kinds of arrangements that you can come up with when there's a dispute that don't necessarily require court intervention. But when you find that those remedies are not effective, you can seek civil remedies. Sometimes you will find that people who are infringing intentionally. That means they have no intentions of stopping because they are gaining economically from infringing on your intellectual property. So in such a case, you want to immediately you want to take an injunction to stop them, first of all, from infringing on your property or on your IP before now you litigate the whole matter until it is concluded. So you can get that an injunction. You can have those goods actually seized, and you can have the goods destroyed. You can have them account for profit. That means if they've been gaining from infringing on your property, they account for profit, and that account for profit can actually be transferred to you. They can pay you damages for infringing on your property. You can get tracing orders. So that means if the goods are somewhere, the person who is infringing maybe has been arrested, and you get tracing orders, they will be compelled to tell you, say if it's goods, where are those goods which are infringing on your property being manufactured, where are they being passed, which places are they been taken, which countries are they been moved to. So you're able to trace the movement of the goods for purposes of seizing them and destroying them. That applies a lot with counterfeit and also with pirated goods. Yeah, I think those are the things that we can look at in terms of civil remedies. And that is the end of my presentation.
We have two or three people, Anne, Charity, and Liz, who are asking, how practical is the trade secret clause drawn in employment contracts for employees, indicating that the employee may not engage in any other employment or businesses of a similar nature during or after a certain period of their employment with you?
Okay, that's the non-solicitation clause. Okay,
yes.
Okay,
the one you were talking about, trade secrets, yeah.
Yeah, where trade secrets are concerned, it needs to be a wholesome approach to everything, such that when you were talking about non-solicitation or non-compete clauses, non-solicitation meaning that they once they are leaving employment, they cannot now again solicit within the workers somebody that they can actually hire to go away with, and non-compete meaning that they cannot compete in a similar business of that nature for a period of time. They are effective, yes, but they need to be used in together with the other forms of protection where trade secrets are concerned. So they are effective, perhaps not just, but they cannot be used alone by themselves. It is just one of the tools that you can use to ensure that that you've protected yourself, that you're sufficiently protected. Yeah.
Okay. David Moretti is asking, would you kindly comment on the proposed IPOK bill, IPOK, and what effect it will have on registration and enforcement administration of IP?
That legislation, more or less, if you look at the current legislations that are contained in the current legislation relating to IP and that particular one, you will see that there isn't much of a difference. What it seeks to do is to consolidate all those IP laws into one and to create one office that will manage IP in Kenya. But if you look at the nitty-gritties of it, there isn't much of a difference. But it's still in the bill stage right now, so people are still making comments. We don't know what the final product will be, but from what we've seen, you know, the substantive part of it is actually similar. It's the same thing.
Okay. So Catherine Wakesa is asking, what if I come up with a working model of doing something in a specific industry and I want to copyright the model? For how long is it able to be copyrighted and what's the process?
I think we had covered this.
Yeah.
Yeah, it depends on what exactly the copyright is, so that the length of time to be copyrighted would depend on the type of work of the copyright it actually is. And yeah, it takes 7 days, a maximum of 5 to 7 working days, and they're now automated. Kekobo is automated, that is where we register copyright, and they're now actually automated. So it takes a period of between 5 to 7 years. The period of time the protection lasts for will depend on the model, which we had discussed.
Thomas is asking, where would you place mobile applications in the IP spectrum? And how much would it cost?
When you talk about mobile applications, you know, that's a product that you're creating. And you will find different aspects of which will be covered under different laws, different categories of IP. So for example, you want to, it goes into a lot. For example, even from the person who is developing your app, when the person is developing your app, you want to ensure that this person, for example, if somebody is developing the app for you, you're not coming up with it yourself. You want to ensure that this person assigns the IP to you in that agreement. You also want to ensure that this person is not going to disclose that that whatever is doing to you for your app to anybody else. So non-disclosure agreements clauses should be there. You also want to ensure that your app is well protected. You will look at the app and you will see most apps will have an icon that you press on or that you can save on your screen. That is also part of trademark. Yeah. You will look at the text and the writings which are on the app. That is protected under copyright. You will look at certain systemic components of that particular app, yeah, like the user interface. So for long as it's a functional bit of it, it will be protected under patent. But it's not, if it's not functional, it's probably going to be under copyright or under utility model if it's not a functional aspect of it. But if you look at the general, you would have to sit with somebody and see what are they trying to create and sort of like develop a roadmap for them from the beginning of engaging the developer to the end, to the when it's being showcased and everything else. Also, there is the issue of cloning. Okay. So you want to, yeah.
Okay. So James Karundu is asking, how can I sell my IP assets and how is valuation done and who does it?
Okay, this, if I get his question, he's talking about commercialization of IP. So there is several ways of commercializing IP. It can, you can either license somebody else to use your IP either exclusively or not exclusively for a set period of time, where you can agree on how much will be, how much the person will be actually, you'll actually be charging that person through that period of time. You can also franchise. That means that somebody else can, like Java, what Java does, it's a franchise. That means you can set up and still pay the owner of the IP, the owner of the IP rights, you pay them some amount of money to be able to run a similar, run a similar, it's like you come up with the same standards for everybody who actually is going to be in that franchise to be guided by. So those are some of the methods that you can use. And if you meant sell it, as in sell it, it would actually depend on the kind of IP asset it is. For instance, if it is it's technology, you can do a technology transfer agreement whereby you're able to just transfer whatever technology you have to another person, meaning that they can, you can either give it to them and maintain and continue maintaining it. So you have sold the technology to the other person, but you're actually just left maintaining it, or you can just sell it and not even stay on for the maintenance. So there's different methods of doing it depending on what the IP asset is and what the owner of the IP asset wants to accomplish. And then how is valuation done? Valuation is done dependent on a couple of principles, but generally speaking, I think we can undertake valuation maybe at a different rate because it's quite a wide scope of, it is quite a wide subject, but just generally speaking, it is really going to be based on the present value of the IP asset, meaning how much income is that IP asset making at the moment and how much is it likely to make in future. And all that is is calculated depending on a couple of variables that are calculated, it's based upon. And who does it? There is IP valuation experts who actually, and more often than not, it's actually a combination of skill sets that is actually required to conduct an IP valuation. So again, depending on what exactly the IP asset is, then different skill sets will come together in order to be able to perform the IP valuation.
Okay. So James Sapamo is asking, where would you place protection of softwares?
Software also cuts across various forms of intellectual property, but there are certain things that you want to consider, like database. You can do copyright, source code, and object code copyright. Technical aspects of it, you can do patent or utility model, but also you can consider trade secrets. So for example, like things like source code and algorithms, instructional manuals, things that you have control over. You can decide if what you have does not meet the threshold of a patent, or if it doesn't meet the threshold of a utility model, you can actually protect it under trade secrets. That means you also limit access to access by employees, limit who knows what is going on, who has the algorithms and everything else. So trade secret is actually a very good model of protection of software.
Okay. And the last question, we are going, because this is I think this is where the world is, and it was asked by Liz Amolo, who says, how do you deal with YouTube content on patent rights that someone does not steal your idea, either on advert or training as the original developer? What is the legal action on employees who have breached the law of trade secrets? Anyway, answer the YouTube one. How do you deal with the YouTube content or on patent rights? Either on an advert or training.
First of all, patent does not apply to YouTube content. That would be copyright. So what you do, when you upload content online, you must know that under copyright law, the protection is not absolute. The rights are exclusive. You will get exclusive rights to enjoy your copyright protection, but are also certain exemptions. And one of the main exemptions is fair use. And you will find a lot of products or a lot of things which are done on YouTube are actually premised on fair use, where you will find that somebody is using your work so that they can show a video of your work and make a comment concerning your work, critique your work, make a reaction to your work. And so if they are not substantively using your content, you may find that it falls within the ambit of fair use, and then it becomes an exemption to copyright infringement. So when you want to assess the issue of fair use, you want to determine how much of the work are they copying? Are they copying a substantial amount of work or a small amount of work? And then how are they using that work? Are they using that work for commercial purposes, or they're just using it to just make a fair comment or parody, or all those kinds of things? You also want to assess how is the use of their work affecting your copyright, the copyright of your work. So for example, they could use your work in such a way that they have used such a substantive part of work that when you yourself, you want to market your work, nobody's really looking at your work, everybody's looking at their work. So if the use of their work is substantive, then that constitutes copyright infringements. So you look at all those different parameters and you arrive at your answer whether there is infringement or not.
All right. Thank you very much. We are way past time. Thank you very much, ladies, and thank you our audience. It's been such a pleasure. It's been so much learning. I think we have to definitely have another session on IP. I think it's a subject that's quite technical and that we need really to learn more. We shall definitely have the ladies back. Thank you, Nyawira. Thank you, Faith. Thank you, Zalego Academy, our IT partners, for your support. Thank you, NG Support Services, our communications and brand management partner. You've been so helpful. Do not forget to listen to Pearl Radio 96.9 FM in Nairobi. Thank you very much for taking part in this one, and we hope that we shall see you next week, same time, 8 p.m. to 9 p.m. And we shall be discussing what are employers looking for in employees. If you're an employer and you wish to employ other people, please come and find out what your colleagues are doing. If you're an employee and you're wondering whether you're doing anything right, please join us. Thank you, ladies, and thank you, our audience. From us, my name is Grace. I've been your host. And it's good night from us. Thank you very much.